Good morning, everybody, and welcome to this edition of Macro Pro and Friends. Today, I am joined by my friend, Debbie Wilson. Debbie Wilson, how are you?
Hi, Diane. I'm good. How are you doing?
I'm fantastic. So this week, Parma happened. I know I personally wasn't there, and I understand you weren't there, but we've heard a lot about it. What did you hear?
I did. PARMA stands for for those who don't know, Public Agency Risk Management Association. Again, we haven't had live conferences in California for a very long time, over 2 years. Laughlin, Falbo, Levy, and Moresi were platinum sponsors there, and they told me that there were about 1,200 attendees, and everybody was really happy to reconnect in person. So it was a great event, and there were happy people everywhere at the happiest place on earth.
Yes, absolutely. I know we had one of our staff members, one of our managers, Wendy Stevens, who went, and she said it was fantastic to catch up with people, to see people, to visit with people face to face. And speaking of people visiting face to face, you heard of an interesting phenomenon that happened at Parma.
It's kind of great. You know, you guys, we've been doing business over these webinars and cameras for years, and some people never even met each other in person. So it was like a reunion with old friends and new new colleagues and new business partners. So it was really awesome, all the feedback that I heard. And the platinum sponsor, we have them here today, Laughlin, Falbo, Levy, and Moresi. So if you want more information, talk to one of their attorneys. They'll tell you all about it.
Excellent. All right, well, before we get started with our presentation, I just want to go over a little bit of housekeeping. So this presentation is being brought to you by MacroPro and our friends. MacroPro is a document retrieval company. We gather records for your claims and litigated files. So we don't get records just in California or the United States. We've gotten records worldwide for our clients. So we will stop at nothing to get you what you need for your files. Secondly, you're going to receive your certificate today in approximately 1 hour. When you see an email, make sure that you click the blue button and that you download that. You keep it for your records. MacroPro does not maintain those. That is up to you to maintain. Now, if you are just phoning in, you want to make sure that you log on to the GoToWebinar platform in order to receive your certificate. That's the only way that they can make sure that you're logged on and able to watch your time. All right. In addition to that, we have handouts for you today, so please make sure that you download those as well so that you can refer back to them. And then lastly, if you have any questions, there is a chat or question box in the console. Please make sure to utilize that so that we can ask questions of our experts, because we have a fantastic topic. Debbie, you want to tell us a little bit about you and what our topic and about our speakers, please?
Absolutely. Amitros is a professional administration company. We manage settlement funds for injured individuals after a claim settles. They're used to having an adjuster, an attorney, sometimes a case manager, and then when they settle their case, they're left on their own. Amitros acts as an advocate, and if there is an MSA, Amitros is responsible for reporting to Medicare on the injured party's behalf. With me today, we are going to be speaking about overcoming settlement barriers, utilizing MSAs, structured settlements, and professional administration. I have with me today Omar Behnawa from Laughlin, Falbo, Levy, and Moresi. He is the managing partner for the Orange County office. Hi, Omar.
Hello.
I have SHAWN Dean with me as well. He is our General Counsel and Senior Vice President of Risk and Compliance for Amitros. Hi, SHAWN.
Hi, good afternoon.
And I have NICOLE CHAPPELLE. She is our VP of Settlement Solutions. She has been in the trenches and she knows what you deal with day in and day out. Welcome, NICOLE.
Hi, Debbie. Thanks for having me.
You're welcome. We're going to get started, and Omar's going to kick us off, and we're going to start speaking about early resolution of your workers' comp claims.
Thank you, Debbie. So before we get started, we would like to make this interactive. So if you have any questions, as Debbie was saying, just go ahead and write them in the chat, and we'll take them on as we get them. So early resolution, overcoming settlement barriers, any settlement starts with your initial analysis of the claim. So whether you're an attorney, you're a claims examiner, claims professional, you want to try to analyze the claim value as soon as it lands on your desk, right? So usually, by the time it comes to my desk or your defense attorney's desk, you should already have some medical reports, and it's usually litigated, so there's an injured worker attorney on board, but you always want to make sure you have that analysis. So when this claim lands on my desk, for example, I will generally have medical reports. I'll know what's going on, if the claim is admitted, denied, if there's temporary disability exposure, what the permanent disability value is. So the way we do that, and the AMA guides for workers' compensation laws have made it a lot easier, not a lot easier, but easier. So for example, the most common injury in workers' compensation is orthopedic injuries, a low back injury, right? So you get a low back injury, per the AMA guides, you will know what the permanent disability value will be. So per the AMA guides, if there's most of these low back injuries will fall into a DRE category 2, which is 5 to 8% whole person impairment. So if you have that impairment amount and you adjust it, you rate it after adjustment for age and occupation, you're going to know what your permanent disability value of the claim is. And then you're also going to add in, if you have any temporary disability exposure, what the future medical care exposure is, what your litigation costs and medical legal evaluation costs are, so you can value your claim. Certainly by the time you send it to your defense counsel, because it's represented, you will know what your exposure generally is, right? So if you could settle for less than that amount, hopefully a lot less than that amount, then it's beneficial to you, and that's something you want to do as a cost savings, so you're not paying too much on these claims. And again, so if you're looking at that on our slide there, number trial versus settlement, the second bullet point there, all attorneys want to go to trial. We went to law school to go to trial. So I have a lot of these discussions with my clients as to whether or not we want to settle or we want to go to trial. The only person that usually benefits in going to trial, and you guys are probably aware of this, is your defense attorney. They're the only ones billing for this. The injured workers attorney gets a fee of the settlement or the award at the end when the case goes to trial and there's a findings and award. But everybody, the defense attorney is essentially billing as they go, right? So, you know, if your defense attorney is recommending settlement, it's usually because they have a fiduciary duty to tell you that. So you don't want to settle all your cases. You only want to settle if it's a substantial savings or a savings to you, and it's a case-by-case analysis. So we kind of talked about a claim coming on my desk, for example, or a claim coming on your desk, and you know it's a low back injury, for example, just to give you a quick example. And most of these low back injuries are going to be 5 to 8% whole person impairment. But if there's radiculopathy, meaning there's pain radiating from their back down to the legs, per the AMA guides, you will know that that jumps up to 10 to 13% whole person impairment per the AMA guides. And if you rate that out for age and occupation, it's going to be about 20% permanent disability, right? Just to use an example, 20% permanent disability equates to about $22,000. So if this is your claim, you're looking at the PD value of $22,000, not counting potential temporary disability exposure, litigation costs, medical legal fees, medical care, future medical care, all these things. If you could settle for 10 to 15,000, obviously that's potentially a huge savings. So these are the discussions you want with your team. You're engaging your attorney and your resource partners to see what you could do to get out of these claims sooner for a beneficial amount, right? So again, the example I just used happens a lot. A lot of times we get these medical reports and it's a low back injury, and you'll see in the subjective complaints, the injured worker is complaining of pain shooting down their legs. Well, if that's verified through clinical findings, you automatically know that it's going to be at least 10% whole person impairment to their low back when that person reaches permanent stationary status and the claim is in a posture to settle. Well, why would you want to wait until then and pay a ton more treatment, litigation costs, legal costs potentially, when you could potentially get out of it sooner? So the reason we usually want to do that, and as your attorneys and resource partners, we try to recommend that, is because it's a savings to you, and we have a fiduciary duty to let you know that. But again, it's on a case-by-case basis. You don't always want to do that. There's cases where you could have one attorney, one injured worker attorney, for example, or a claimant attorney that's representing multiple injured workers from your company. Like every other month, you're getting the same attorney with another employee. You know something's going on there. And there's cases where you want to fight it to send a message. And of course, you do want to do that at certain times. But one thing I want to emphasize, and as we talk about settlements here, we'll talk about MSAs and things like that. One thing I do want to emphasize is I don't think you can have a favorable settlement unless you're setting your case up to go to trial and to win it. So anytime the claim comes to you, you have to be proactive, right? You have to be proactive from the get-go. You have to, if there's any prior injuries, you get an ISO claims index, that's the claims adjuster. You're subpoenaing the pertinent records. If there was a prior motor vehicle accident with bodily injury, you're requesting and locking in a medical legal evaluator, a qualified medical examiner in orthopedics for an orthopedic surgery, and avoiding a chiropractic panel Q because they tend to be a lot more liberal than an orthopedic surgeon would be. So these are things you're going to do to set up your claim to go to trial and get a favorable finding. And if you're doing that, you're setting your case up like you're going to trial. And at that point, you could settle from a favorable position. Because if not, you're just throwing money at the problem. And a lot of times you will not be happy with the settlement. So if you're going to settle it, it has to be favorable to you, obviously. The way to do that, you have to set your cases up as if you're going to trial, get all your ducks in a row. So that way, when we get to that stage, we're settling it for a favorable amount. When is a good opportunity to do this? The best one, I think one of the best ones is at the deposition. If you're deposing somebody, you don't need a deposition obviously for every claim, but the claims where you are deposing someone because they had prior injuries, because there's a factual dispute, a he said, she said issue, at the deposition, the claimant's counsel is there. They have to, and they do prepare their clients for the deposition in advance. So usually for the first half hour or hour before the deposition starts, they're preparing for the deposition. That always happens. So they know their claim. They know they've reviewed their claim, because a lot of times you pick up a phone, and this has happened numerous times, more times than I can count. You call opposing counsel, you're trying to settle a case, or you as the claims examiner or claims professional trying to do the same thing, and they have so many cases, they're like, yeah, we'll get back to you. Or they'll throw out an outrageous number because they don't know and they don't want to sell their clients short. Well, at the deposition, they've reviewed their file. They've gone over it with their client, and their client's present. All the parties, all the decision makers are there. And hopefully you're there, if you're the claims examiner, to assist your defense counsel if they reach out with settlement requests. So it's a really good opportunity to settle the claim. Everyone's there, and what I generally tend to do, and most defense attorneys I work with also try to do this, is if we're at a deposition in person, we try to fill out the settlement documents in advance. We give our settlement recommendations to our client when we initially get the file. So by the time of the deposition, we already have an amount that we know if we settle for X amount, it's going to be a substantial savings for us. So what we talked about before, if we know somebody for a low back injury is going to have about 10 to 13% whole person impairment, we rated that out. We know what the monetary value of permanent disability is going to be. Could be about $40,000 potentially. We know if the person's currently getting temporary disability benefits, we know what that rate is. We can estimate how much longer they're going to receive that. We know what the future medical care potentially is. If there's no surgery, if there is surgery, you know it's going to be a lot more expensive. All these things you should know in advance, and you should lean on your attorney and your resource partners to get this information. And so that way you know what the value of the claim is. And so if the value of the claim is about $60,000, you know you could settle it at the deposition for 20. Well, you just save a lot of money. And applicant's attorney, they think they got a good deal too. So that's why you want to be engaged. You want to be proactive from the start so you could get a favorable outcome. One thing I do want to point out as far as nuisance value settlements, and you know, we've all settled cases as the defense attorneys. I settled a case for $500, and then the next day I settled another case. The $500 was an admitted COVID claim. It settled for $500 at the deposition. There was the next day I settled another one for $25,000 on a denied site claim. And I was training one of our new attorneys, and she was at both depositions listening in, and she was shocked as to why we're settling one for $500 and one for $25,000. It depends, right? So you always want to gauge your claim. One of the main things, as far as when people ask, well, what's a nuisance value settlement, is the medical legal fee schedule increased in April 2021. So although even if it's a denied claim, if you subpoena records from Kaiser, their private healthcare insurance carrier, Allstate Insurance for a past motor vehicle collision, things like that, you're getting these records and you have 1,000 pages of records. Well, when we're sending that to a qualified medical examiner or your agreed medical examiner, the fee schedule has gone up. So now if anything over 200 pages, they bill $3 per page for, in addition to the 2,000 plus that they're billing for the evaluation. So all of a sudden you're looking at $10,000 just for one evaluation in orthopedics. Now you throw in a site claim, that's going to be way more. An internal claim because they're having issues with their stomach because they're on medications. It's just the value of the claim, the cost to the claim goes up. Now the injured worker is not seeing that, but that's the cost to us. So if we could settle it and get out of it and have a $25,000, $30,000 savings by doing it, it's worth it. And I don't want to spend too much time on this, but just one other thing that's very important: if you have bigger claims, multiple defendants, look for informal settlement conferences, right? So at the deposition, all parties are there. If there's a co-defendant, they may or may not be there. But if there is multiple defendants, you could have a case with 4 different defendants potentially on a repetitive trauma claim, or in instances where there's concurrent employment, right? So in those situations, you may want to consider doing an informal settlement conference, just scheduling it, sending out notice, talking to all the attorneys in advance, so everyone has their prospective clients on board, at least as far as what they're thinking the case is valued at. And that way, hopefully you could settle it and avoid all these other expenditures. Again, there's some other things I want to come to when we talk about MSAs, but I'll go ahead and hand it off here to Sean and Nicole. Next slide, please.
Can you flip to the next slide, please?
Thank you.
All right, thank you so much, Omar, and welcome everybody. I realize I said good afternoon. It very well could be good morning still to those joining us on the West Coast. As a Southern California native, I should transplant to New England. I should know that. So welcome, thank you for joining us, and to my colleagues Nicole and Omar, please feel free to step in and add any color commentary or knowledge here around these. We strategically focused on these bullet points because I think it gives you a wide breadth of knowledge and an opportunity for us to discuss the wide array of topics that are out there, and sort of setting the base of it, protecting the Medicare Trust Fund. That's the primary impetus behind establishing a Medicare set aside. And this stuff goes way back to the origins of Medicare itself, where Medicare, even in the original Social Security Act back in whatever, 64, 65, held workers' compensation as secondary to Medicare. And you fast forward to 1980 to the Medicare Secondary Payer Statute that included its own promulgated regs, and this one in particular that focused on workers' compensation, 42 CFR 41146, and talked about the fact that if you have a commutation of benefit settlement, if you have a CNR, that alleviates the carrier's responsibility of paying for future meds and resolves those for an applicant, that Medicare doesn't want to step in. There's a prohibition for them stepping in and paying for industrially related treatment that's otherwise covered by Medicare until that settlement's spent down. It's a pretty harsh rule. So some really smart folks started looking at that very closely in the mid to late 90s, and in the spirit of that regulation started setting aside, that's why they're called Medicare set aside, setting aside funds in contemplation of paying for those types of expenses. And CMS went, oh, that's amazing. Let's bless that with a policy memo. And in 2001, that's where you saw the Patel memo. And from there was a proliferation of MSA vendors and other memos that CMS came out with, and it culminated in the work comp reference guide that we have now that I'm going to talk about a little later on, with a specific policy provision that's worth noting here. But the whole idea behind this, the whole thrust behind this, is to ensure that there's not a cost shift back over to the Medicare program that's going to encumber or implicate the Medicare trust, and essentially have us taxpayers fit in the bill for treatment that should otherwise be covered by those primary payment funds that came over by way of settlement that were set aside to protect Medicare's interests. So that's the basis for all of this stuff. Now, the next bullet, recommended thresholds for submission, we start to get into CMS guidelines around reviewing. So you have all these decision points when you're talking about an MSA. Do you even do an MSA or do you not do an MSA? If you determine that you need to protect Medicare's interest by way of an MSA, the next question is, are you going to submit it or not submit it? You have another question of how are you going to fund this vehicle? Are you going to fund it via a lump sum, or are you going to go to a life company and get a structured settlement? Are you going to have it self-administered or professionally administered? So there's all these decision points within the overall MSA process, and this is one of them when it comes to submission. And here's sort of where we're at. If you look in the WCMSA reference guide, CMS indicates, as they always have, that submission is a voluntary process, and CMS will, based upon what they refer to as their workload review thresholds, allow for submission of an MSA in two instances, essentially. One, this is where it goes to the recommended thresholds, where an individual is currently a Medicare beneficiary and the total settlement amount inclusive of the MSA exceeds 25 grand. The second is a little bit more trickier, and folks kind of get tripped up on this sometimes. It's if the individual has a, quote, reasonable expectation of Medicare enrollment within 30 months of the settlement, and the total settlement amount inclusive of the MSA exceeds $250,000. Now, Sean, you might be asking, what is a reasonable expectation of Medicare enrollment? It's if someone is 62 and a half years of age or older, if they are currently receiving SSDI benefits but are not yet entitled to Medicare, if they've applied for SSDI, if they've applied and been denied and reasonably anticipate appealing an adverse decision. Those are the instances where they could be deemed to have a reasonable expectation. And the associated requisite review threshold is anything over 250 grand. So that's that as far as submission. It's voluntary. CMS indicates that there is not a legal, statutory, regulatory mandate to submit an MSA, but keep that in the back of your mind when I get to the bullet down here and I talk about recent updates to the WCMSA reference guide. Another question that I think a lot of folks ask is, when is a revision necessary? So you're chugging along, you got an open claim, you did an MSA because you want to have some idea of what the future medical exposure is going to be like, but you're not sure if you're ready to settle the case yet. You're thinking about it, maybe 3 or 4 or 5 or 6 months pass, and you're ready to move forward with a full and final settlement. At what point is that MSA potentially stale? When do you need to have it revised? Well, I think it's a question that necessitates an analysis based upon case by case. And I think the primary question to ask is, what treatment has changed? What course of treatment has changed since the time you did the MSA till the time you're contemplating settling the case? If, you know, I think as a general rule of thumb, it seems to be an industry practice that 6 months seems to be the answer, but I don't know that that's a hard and fast rule necessarily.
Hey, Sean, Nicole.
Yeah.
So I just wanted to engage you in that conversation around revisions. I always think that that's something from a claims desk that people are a little confused around. And I think it speaks to, when you're getting an MSA, making sure you're ready for an MSA is a huge point. And also making sure that the medicals that you're submitting are reflective of the injuries that you're admitted to. I've seen over the years, sometimes they're not redacting denied body parts or non-industrial body parts. And MSAs are then being valued based on body parts that we're not even accepting on an industrial level. And so an MSA can be increased in value significantly if you're not preparing the medical reports in a proper format. And to your point about revision, is the revision, has anything changed? It's going to alter that value is also really important. You can't just presume somebody is going to go to a generic medication from a name brand and think that that's going to reduce your value.
Now, you brought up a huge point there. Like, is it the appropriate time for the MSA? If you obtain an allocation report in the throes of really high utilization and active treatment, right, where you have no idea what the healing curve looks like, right, it's going to be all over the place. The bar graph's going to be up and down, and you're going to have no idea. If you wait and they reach MMI and things have stabilized and they haven't treated in half a year and the regimen is, the pay history reflects that their regimen's the same, then probably a revision may not be something that's totally necessitated. It's for sure for case by case.
Yep, and I also think that we've spoke about this before. They're discoverable. So sometimes if you're releasing the MSA, an applicant's counsel and/or the applicant gets a copy of it, then they're focused on that value. So it's harder to walk it back. So if they see that we had, a $90,000 MSA, and to your point, you're in the throes of treatment, but their treatment plateaus, there's no need for additional surgeries, they've declined surgeries, things that were included in the MSA, but they're stuck on that 90,000. It's really hard to engage in settlement negotiations when the injured worker has a value in their head.
100%.
Just to add in a point, because what you both said is an excellent point. So what we do is before we get an MSA, because getting an MSA is a cost to our client, right? The MSA vendor is going to charge them something. So why would we get an MSA when there's no reason to? And so when we discuss settlement, the first thing we'll ask opposing counsel is, do they want to settle this? And because they might be Medicare eligible or have a reasonable expectation, we'll ask them, well, we're not going to get this MSA unless we are ready to settle this thing. And so they'll talk to their client, and we will proceed with the MSA at that point. The next point you made about zero allocation MSAs, or not zero allocation MSAs on a denied claim itself, but on a denied body part. That's huge. And honestly, a lot of applicants, attorneys, a lot of people are not too familiar with this. And
right.
we talk about war stories. I was at an expedited hearing, an expedited trial, and we were trying to settle this claim, this really nasty claim where it's an admitted orthopedic injury. Now they're bringing the heart and cardiac claim because he can't have right knee surgery unless the cardiac issues are done. And now they want to have this heart surgery as part of the work comp claim. So we're talking about an MSA, and I'm telling applicants counsel, well, no, the cardiac claim is denied. And we actually have something from the judge that's saying the cardiac claim is denied. When we get an MSA, that's not coming in. We've never paid anything for the cardiac issues. If you look at the benefits printout from our client, nothing's been paid. And from my understanding, when you're denying a body part or the claim itself, if there's been no payments made for that body part, generally CMS will approve that there's nothing paid on the body part. Believe it or not, I told applicants counsel, the claimants counsel, that we could call any MSA vendor right now and they will tell you this, because it was such a holdup. He actually called his own MSA vendor, whose cell phone number he called, and he verified exactly what we were saying. And a lot of the barriers to settlement that we're talking about is just the lack of knowledge on these issues. Even with the threshold amounts, the $250,000 threshold, people don't know that. They think, well, applicants' attorneys will, no, I'm not going to settle unless you submit the MSA to CMS on a $100,000 settlement, but they're not currently Medicare eligible. And the only thing that will happen is CMS will send it back and say, this doesn't meet the threshold for guideline review. So just knowing this and being able to relay this to the opposing party is huge a lot of times to effectuate settlement.
Yep. And just to circle back around so Sean can finish his bullet points, which he's doing so excellently, is also the fact it's a reason to settle the cases earlier. As cases mature, they're not like wine. They don't get better. People get older. People have arthritis. People have gastrointestinal injuries. People suddenly add on the body parts that were initially part of the initial mechanism of injury. So the sooner you're able to intersect a resolution, the better for all parties.
Thanks, Nicole. So taking a look at large MSAs and potential strategies to lower them, including structure. So, and obviously at Ametros, Nicole and I, we're not allocators. Major props to all the nurse allocators out there. Those folks are brilliant and they possess subject matter knowledge that I never will. I've worked very closely with many of them throughout the year. So any nurses on the phone, amazing job that you do, and keeping up with all the changes that CMS has that they come out. I can speak at a high level of some of the things that folks look for. You typically look at any high price surgical procedure that comes along with it that may have a revision that's associated with it, or other ancillary treatment that makes it really high. High prescription drug costs. I think probably prescription drug cost is one of the largest areas of opportunity for folks to look at for cost mitigation because of frankly, just frequent utilization and overutilization potentially of certain high cost pain medication where there's an opportunity to get a second look at it and to make some recommendations if it's permissible in that jurisdiction for alternative treatment, either titration or weaning of meds or different modalities of treatment that don't involve those prescription drugs. You know, a lot of times there are pain pumps and spinal cord stimulators that are in Medicare set-asides, or at least implicated potentially in going into a Medicare set-aside, that can just drive the costs up so much where they're cost prohibitive from a settlement perspective. And sometimes just the mere mention of a recommendation in there causes CMS to allocate for those, and it makes it very difficult for the parties to move forward. I think those are some of the reasons why, and you can certainly talk to your respective MSA vendors out there around cost mitigation procedures that can take place. But in regards to those high ticket items, I personally feel, it's just my view, why you've seen the increase in the last 4 or 5 years of non-submit Medicare set-asides to forego submission to potentially reduce or eliminate those high ticket items to allow the parties to get to settlement. But there's also here strategies to lower, including structures. I think certainly most of the Medicare set-asides we see are funded by structured settlement, just because it provides a lower cost alternative to funding the allocation. They're essentially not spending all the dollars up front and funding that via lump sum, and they can receive some financial relief there. And it also, there's kind of a collateral benefit to that too, where it provides a steady stream of income relative to those medicals. And if those funds are temporarily depleted in any given year, CMS steps in and pays primary. So there's some benefits around that. But I don't know, Nicole or Omar, if you have any thoughts around cost mitigation and maybe strategies to lower costs in MSAs from your perspectives.
Just the one thing I would add to that, and what you indicated is 100% true. These allocators do a great job. So they'll see what the future medical care, what would be necessary. The problem is, unfortunately, California law, for example, is different. There's limits to how many physical therapy visits you get statutorily, right? So if someone, I just saw an MSA literally yesterday, an MSA came back at 163,000. There's a bunch of other things on there, but there was 84 physical therapy visits. So for example, your attorney should be looking at that too, and you as well, because if there's statutorily, if there's a limit to the amount of future medical care, well, your MSA vendor allocation team might not know that. So you want to, just like Nicole was saying earlier, you want to let them know what body parts are actually admitted and what body parts are denied. You also want to tell them that there's only a 24 visit cap.
There's a cap, right?
Physical therapy, yeah, there's a 24 visit cap, so you can't do this. Another thing we see a lot from our end, for example, is you'll see in California, Labor Code Section 5402, the first 10,000 on a denied claim, the first 10,000 in a medical care before you admit or deny a claim during that period where you're investigating the claim, defendants have to pay for that, up to 10,000 in medical care while you're investigating the claim. Well, if it's a denied claim, it's a zero allocation MSA, you submit that zero allocation MSA to CMS, they're going to say, no, you paid $8,500 treatment through this period. Your MSA vendor is going to need to explain to them, hopefully in advance, that California law, it requires us to do that. So even though the claim was denied, during that investigation period, we had to make this payment. So that's the only thing I would add is there's also legal, statutorily, there's things we need to do to make sure that the costs don't go up, because you don't need to issue that payment.
And just to circle back to that, and I think I agree with everything you said, I would also make sure that you're tightening up your medical reports from your physician. So if somebody do they really need that surgery, or if by the fact that they get progressively worse, then they need a total knee replacement. Those types of things where you're asking a physician to be specific to the treatment regimen is very helpful when mitigating costs. And additionally, if somebody is on a name brand and it's something that can be switched to a generic, do it sooner rather than later. People will fight back. You will have injured workers who make comments around it. But I think it's important to make sure that you're speaking with the physician, not leading the physician, but making sure these reports are written properly so the MSA is not being vague in their assessment. Hi,
we
Diane.
have a question here. And our question is, they wanted to know if you can explain the difference between a lump sum and an annuity.
So a lump sum, as far as a compromise and release, it would be a lump sum value of a case in chief. So an annuity would be a structured program where you're setting aside a certain amount of money on the front end. So you'll go out and you'll get a quote, and maybe they'll say, of the settlement value, you seed money of $30,000 to $40,000, and then the rest of it is put into a new annuity and paid out incrementally. A lump sum releases the funds to the injured worker in full entirety. And so that is part of the reason why we're here to talk about professional administration as well. Lump sum on an indemnity has nothing to do with the medical exposure. Lump sum on a medical behests the injured worker to manage their future medical going forward. That is something that I think is usually asked for because people look at that as their payout and a settlement. What they don't understand is that it is a projection of medical going forward. It's not a reward of medical, it's something assuming that you would continue to have active medical care. So to clarify, a lump sum releases all the funds to the injured worker, less an applicant attorney fee when applicable. An annuity has seed money, and then the rest of the balance of the settlement is paid in incremental payments.
Yeah, and I think the only thing I'd add to that, that's exactly right. I would just say in the context specifically to an MSA, lump sum versus annuity just goes to the funding mechanism. Are you paying the entire amount upfront, or are you purchasing from a life company an annuity to fund it on an annual basis? There's obviously a seed. It's seeded to cover initial costs, and then there's annual payments thereafter that are going to equal the total amount of that purchase annuity, which would fund the MSA at that total amount.
Right.
Over the life of the individual.
Okay, along with that question, they're wondering, and I don't know if this will be later on in the presentation, but they're wondering if you can explain the difference between professional administration and self-administered.
I'll take that. We are, it's on a later slide, but I would love to speak to that now. So self-administration is what we were speaking about briefly around releasing the funds to the injured worker, and then they're responsible for managing their care. The thought behind that is that you would use that money over the next X amount of years of your life expectancy to manage the medical that was awarded to you from your workers' compensation claim. That's a pretty big assumption. A lot of people will get that money and use it for other things. They will pay off bills, or they don't have the ability to negotiate bill review and reduction of costs, so they run through that money really quickly. Professional administration allows you to navigate future medical care with getting yourself out of workers' compensation, which a lot of times you've been in these claims for multiple years. There's some anger and frustration about being in the workers' compensation system that ceases when you come to professional administration, but you have the benefit of having somebody manage your money in a proper way and extending your funds. So administration is us taking over the role of the carrier or TPA, but taking you out of workers' compensation. We have PBMs, we have physicians and locations that sometimes an NPM may not be available to an injured worker. It allows you to itemize and take care of your funds in a really aggressive manner. And if there is an MSA, we will take care of all that reporting that is very burdensome as well. So self-administration means you manage yourself. And frankly, I've been in workers' comp for 30 years, and I'm pretty sure I couldn't do that. I also know that I probably wouldn't have the ability to negotiate reduced fees with doctors or get reduced costs on pharmacies. So I think it's really advantageous and protects the injured worker going forward. So I hope that answered the question.
Cool. Thanks, Nicole. I couldn't have said that better. Thank you.
My pleasure.
CMS approval times, really briefly, there was way back when, years and years ago, there were issues with the prior contractor, and I think some of those fears still persist, but by and large, I mean, when I talk to my colleagues who are submitters, a month, sometimes 45 days, if the case gets developed and there's additional documentation that's needed and there's tons of back and forth, or there's a counter hire and there's a request for re-review, then obviously that can add to the timeframes, but by and large, to CMS and the contractor's credit, they're fairly quick with turnarounds. I mean, I remember way before there was the WCMSAP and you had to submit them, fax them over, mail them over. It certainly took a long time, but I don't think we're in that type of scenario where the timeframes are going to be prohibitive if folks are considering submission. It's obviously their call too, but as with submission, this is probably the biggest update on the slide, and it has to do, the second to last bullet, has to do with a written policy position that CMS formally took in the Work Comp Medicare Set-Aside Reference Guide. It's found at section 4.3, and I'll do my best to summarize it off the top of my head. Essentially, it is CMS's stance with respect to non-submission and calling out non-submit products or evidence-based medicine products, that CMS views those vehicles as a per se cost shift over to the Medicare program in contravention of the applicable Medicare set-aside reg that I had rattled off earlier. And as such, CMS takes a position that they will deny, can deny medicals up to the total amount of the settlement, not the non-submit amount. And let me just let that sit for a second. I'm just going to step back and sort of explain it maybe in a little bit more detail in a simpler way. I explained what an MSA is. You can either voluntarily submit it to CMS if it meets those thresholds, or you don't have to. And CMS is clear in their reference guide about that. Oftentimes it comes down to, the decision comes down to a risk management decision up against the potential cost, and the parties, by and between the parties, agreeing whether they're going to submit or not. It's not like it's a statutory mandate. CMS took the position that if you don't submit, that they view those instances is somehow violating the MSP provisions that are applicable to WCMSAs, and as such, they're saying they can deny costs and will require a showing that those that Medicare covered expenditures were up to the total settlement amount. Now, what happens in a submitted case, and I'll use round numbers because I'm horrible at math. Let's say the MSA itself was $100,000. Let's say the settlement was 200 grand. The MSA was 100 grand. In a submitted case, if it can be shown that the $100,000 was properly expended on Medicare covered items and services, CMS will then thereafter step in and pay primary for any industrially related treatment. Let's say that there was a $200,000 settlement and a $50,000 non-submit that was done. So the folks came together, the parties came together and say, we feel that it's $50,000, we're not going to submit it to CMS. In that event, if it was shown that the individuals expended the $50,000, CMS is saying they're going to require the whole $200,000 to be spent down on Medicare covered meds. This is CMS's position. There's been quite a bit lately that's been written about it. It's not necessarily a shock or a surprise, because this appears to have been their position, at least informally, in industry trade conferences for a while now. There's been copies of redacted letters circulating showing CMS's response to when parties voluntarily put CMS on notice that they've done a non-submit. I think as far as guidance, I think professional administration is more important than ever in these situations to maximize utilization of the funds and to ensure that they're spent properly. I also think that it is a little bit of wait and see to see how this policy is actually implemented in practice.
Hi, Debbie.
Hey, hi guys. We have a couple more questions, Sean, like kind of lining right up to what you've been talking about.
Sure.
One, someone asked, where does the money go if the beneficiary dies, if the injured worker dies, and there's money in a professional administered account? The second question we have here is, how often do you see a self-administered individual get denied Medicare coverage by Medicare?
Okay, wow. So the first question is, where do the funds go when the individual passes away?
Correct.
So the funds, and that's a good question. So CMS is pretty clear on that, and they provide guidance in the WCMSA reference guide. They also provide guidance in a CMS decision. And I'm a geek about this stuff, so I know where it's at. It's at the FAQ in there at question 10. and they indicate that they honor what the settlement states. So if the settlement dictates that the funds upon the death of the individual are to pass to the estate, then that's where they go. If the settlement dictates that the funds are to go back to the original payer, then that's the disposition that occurs. There are some parties that decide we want it to go half and half. We want half to go to the beneficiary's estate, and we want half to go to the payer. So I guess that's a long answer. Short answer, Debbie, to the individual asking the question is, it's whatever the settlement indicates, and that is predicated on what the parties decide by and between themselves. And then the second question was how often do we see
Denial.
How often do we see denials in self-administered cases? Correct. So that's a great question. And we actually, a colleague of mine and I wrote a study, and kudos to Jason Gallant for doing this, went and found some data on this. I don't have the study in front of me, but I will tell you it's not insignificant. And I believe it's upwards on average of over the last 4 or 5 years, 12,000 Medicare beneficiaries, something around that range per year that it's happening to. And totaling, I think on average, I think it's $35,000. I could be wrong. You can certainly go to, not a plug here, but you can go to amitros.com and go to our blog section and find the study. But that's sort of kind of in line with what I was talking about non-submits and denials. So there are, the biggest thing for us is there are mechanisms that CMS has in place to effectuate denials in these cases. And the work that Jason did on this study shows that that Medicare is in fact out doing that.
Yep.
I can skip the last bullet if you want to keep moving. I want to make sure I give you the balance of time.
Yeah, I know we have a hard stop at noon. So is it possible? And again, we'll be releasing the slides. So if there's any questions, feel free to reach out to all of us and we will do our best. Let's move to the next slide because I have to respect the time deadlines. Thank you so much, Sean.
Trying.
I appreciate your effort, Debbie.
I'm trying. Yeah, this is, there we go.
Perfect. So some of these things we've already spoke to. So once again, CMS highly recommends use of professional administration. We hit on some of the bullet points earlier. Amitros works as a neutral third party to administer future medical funds. So as I spoke about briefly, we give you the benefits of workers' compensation, bill review. We give you the additional benefit of not having to utilize an MPN. We've had people make requests for physicians closer to their area, and we're able to accommodate that. Again, we're getting reduction in costs for pharmaceuticals. So you're able to go to any doctor, any pharmacy, and there's no utilization review. And I know in California, that's a significant issue. Not only do you sometimes get denials of care, you end up in litigation. I'm sure you can speak to that, Omar, around treatment, whether it could be an expedited hearing or an IMR, that's delaying care. We receive the provider bills. We do review bill in-house, PBM discounts. So it's things that you're getting the benefit of using that money and extending your funds. Once again, we're compliant with CMS if managing an MSA. I wanted to add in here that professional administration does not require an annuity, nor does it require an MSA. We are able to manage all future medical funds. So MSAs give you a finite figure to work with, and an annuity, whether indemnity or medical, is beneficial. You do not have to use an annuity or have an MSA to work with Amitros. Also, the severity of injury is not a requirement. We have cases where the value is really low, but we also have cases where there's complex claims, and we have the ability to manage to all types of claims. We can also attend informal settlement conference and mediations to speak to our benefits. So sometimes if you just need somebody to explain it to the applicant's attorney with defense counsel to the judge, we are your people to help you in that space. And once again, we're neutral. Again, it's mitigating concerns of the injured worker to having an advocate. So they've been in the hands of a claims examiner, a supervisor, a nurse case manager, their applicant's attorney, a paralegal, all these sort of tools in a toolbox, and now they're on their own. And we can advocate for them, but also give them that independence so they can navigate through the future medical system. And once again, here's our link. And as Sean had referenced, you can also see the white paper that we wrote, and there's a lot of resources there. So we would love to work with you, but please do not hesitate to look at the site. There's a lot of FAQs there that could be very helpful to you. Next slide, please.
Trying.
You're just making me do like, you know, you're making me do museum face, like stand still.
With this
Is my
computer,
smile
it's
good,
just,
Debbie?
I don't understand why my keyboard's messed up. It's just not moving forward here. Trying.
I appreciate you.
Hey, Debbie, click onto the screen and then you may be able to activate that again. There we go.
Awesome. So just as we had talked about in the beginning of the presentation around earlier resolution, here are some great settlement triggers that align with what Omar had spoke to earlier in the presentation. We can be involved as early as an MMI report that's not been acted upon. We prefer that. We use it as an opportunity to work with you in the settlement negotiation process. You as a claims examiner or a supervisor or defense counsel, obviously the quarterback ultimately for the negotiations, but we're able to speak in a space while you're moving through that process, we can look at the value of the medical. Is this something that needs an MSA? Is this something that you should wait for X amount of time? Things to that effect. So as an MI report comes in, you're usually ripe for settlement. A case that's been submitted, but you're waiting for CMS approval is a perfect time to align with us. If a CMS is in the next 30 days, it's another opportunity for us to reach out to us and coordinate in the settlement process. We really love situations where there's a balance due on an indemnity award. And why I say that is what we spoke to earlier with Omar. The fact is, a lot of injured workers feel like their future medical is their money, and that is their win at the end of the settlement. Sometimes the indemnity has been paid out, or there's a very low value of indemnity and the medical seems like a high exposure. If we have some ability to leverage indemnity as part of the global settlement, they're more prone to put their medical on our platform going forward than presuming that they're getting no money from their settlement. Cases where there's pending hearings are a great opportunity for us to attend. We can do it virtually, we can do it in person, and just speak to our product and sometimes assuage some of the fears that an injured worker may have. We spoke about this briefly the other day. A lot of times the applicant's attorneys will recommend to their client to go with a MSAs or a professional administration, and then they're done with the case. And the injured worker really doesn't know what a MSAs is or what we can do for them. So if we're in that conversation earlier, I think we can eliminate some of their fears. We love participating in litigation roundtables or batch settlement days. I'm in California. We have the capacity to go to a lot of different hearings. I've spent a lot of time in Southern California. I'm in Northern California presently. So feel free to reach out to me in that space. And once again, with improper applicants, it's really a great opportunity for us to advocate for the injured worker. It's a situation where there's a lot of acronyms, there's a lot of fast talking people, it's confusing, there's subjectivity of pain, it makes people uncomfortable, and sometimes they just need somewhere to vent. And we would love to be that person for that injured worker. So if there's any questions, please feel free to ask them. I know we're up against it. We're at 11:54. I think that was my final slide. But I've enjoyed so much speaking with my colleagues, Omar and SHAWN. And thank you so much, Debbie, for the opportunity to speak today.
We thank our friends at MacroPro too.
I know,
for
Diane.
hosting us.
Thank you so much, Diane.
You're quite welcome. I actually got an email while you were speaking saying it was a very good topic and they really appreciated the information.
We love that.
It's immediate feedback, right? I think education is so important, and MacroPro is so proud to be able to provide these webinars to our clients and to your clients as well. Any last thoughts on the subject? Omar, do you have anything you'd like to end with?
Just one quick thing. SHAWN talked about the CMS approval times, and they're much better than they used to be at some point. But, you know, most people still think they take a long time just because they used to take a long time, right? So we can use that to leverage favorable settlement because the threshold amounts to $25,000 and $250,000. So why go through the CMS approval process if we could settle for less than the threshold amounts? And I could tell you in California workers' compensation law, you see so many settlements just under $25,000.
Exactly.
So 24,500, 24,999, and even the judges know what's going on. But it's done for a reason because there was a time when it was taking months on end to get the CMS approval. And so if someone had a $30,000 demand, they would cut it down to 24.5, and that would help us. And along those same lines, the $250,000 threshold figures there. So somebody that's 63 years old, we can settle that. We could use that as leverage to hopefully effectuate favorable settlement for us, and all parties use it.
Correct. I agree.
Anybody else? Sean, would you like to end with a statement or thought?
You know what I want to say? I want to thank you at MacroPro, Diane. I want to say hi to Mandy Farquhar over at MacroPro. She is one of my favorite people in the world. I have no idea if she's listening or not, but I just want to say hi to her, and we love her. She's amazing, and so are all you. And we appreciate everyone joining today.
She is definitely online. Nicole?
I just really appreciated this opportunity. It's been a really wonderful way for us to interact. I can't wait to see you guys all in person soon. And thanks again, Diane, for the opportunity.
Yeah. Debbie, would you like to say anything?
Yeah. The contact information from Omar, Sean, and Nicole are on the first slide. Diane has that as a handout on the webinar right now. So please download that, keep their information. We want to be a resource to you. Any case you need to talk about, please reach out to any one of us, and we'll be making sure that we get back to you and talk through some of the scenarios and some of the ways we can help you overcome, these barriers to settlements. You have all of us in your back pocket. So just know that we know your jobs are hard. We know you work very hard and tirelessly trying to help these injured individuals do your job. We know you have a lot on your plate, and we want to be there to help you. We don't want to stall settlements. We want to help facilitate settlements. So please utilize us in your day-to-day activities, and hopefully we'll hear from you soon. And we thank you again, Diane, for allowing us to be part of this webinar.
Certainly. And I'd like to close as a reminder, you will be receiving your certificate within 1 hour of this presentation. So make sure you download it and you keep the original copy for yourself and provide a copy to your employer. If you need records for any MSAs or anything else, well, MacroPro is the company for you. Feel free to reach out to me, Mandy, Wendy, any of our salespeople will be happy to take care of you and make sure that you get the records you need. And then lastly, all of our webinar information is on the MacroPro homepage. So you don't need to wait for an email saying that there's going to be a class. You could simply go to macropro.com and our educational opportunities are there for you. We do have an upcoming in-person event in the end of this month in Rancho Cordova. So we certainly hope those of you that are in the area that we will see you then. All right, everybody, have a great day and thank you again, experts. Bye-bye now.
Bye, thank you.